form, or it's just stamped by the department?
Right, so my understanding is when a re-registration form is filed, it's filed with the property file, and it's also scanned online, so it's easily found if one exists. And then it's filed, if it's filed at City Hall, so the form is in triplicate, and so it's one copy is filed with the city, one is retained by the landlord, and then one copy goes to the tenant. If it's filed in person at the window, the city gives it that received stamp. If it's filed by mail, then the landlord can come in and get the received stamp from the city if it wants. In the absence of that stamp, in any event, the city will also send a confirming letter to the landlord. I don't remember the name of that letter, but it's something like confirmation of maximum allowable rent. So the department confirms essentially what the information is in the re-registration form. So it sends a letter saying, based on the re-registration form you filed, this is what the maximum allowable rent is that you're claiming that you're charging your tenant.
Oh, so there would be a confirmation of letter sent, basically.
Correct.
Stating that. And the city will keep the electronic format of these files. They're scanned, as you mentioned, that the forms will be scanned.
Right. Up until recently, the hard copies were kept on site. I believe there's been a shift over to online, so you can search. I don't know if it's searchable by the public. I should say it's searchable by staff, but it was scanned. I'm seeing nods, so I think I got that right. It was scanned to the database that the city keeps, and so it's accessible to staff, a little more readily accessible to staff who needs to try to find it.
Okay, so the most important thing that I wanted to understand, if that when the property owner submits it at the counter or at the department counter, so the employee will stamp it, and that would appear on the front page, the date and the time, probably. All right. Thank you.
Just to follow up on that question, do you know approximately when the procedure for sending the confirmation letter began? What year, roughly?
I assume it was when Costa-Hawkins was implemented, because that's when all of this changed over. So that would have been 1995.
Okay, it wasn't a new policy then that
No,
we
it's been
changed.
over 20 years.
Okay, thank you.
So just to confirm, I talked to Peter Noonan earlier today, and I thought that he said there was just one copy, just the physical print hard copy, not that it's both scanned and somewhere else, but it's actually both scanned and a print hard copy. Is that correct for the re-registration?
Well, we have the hard copy that we get, thank you, but we scan it, okay, and that stays on our database. We keep the hard copies for now, okay, and they're sent off. I'm not sure how soon to file keepers, but our basic reference is the scanned items.
Thank you.
You're welcome.
And I had another question. In the hearing record, it said on page 4 that after the hearing examiner asked a staff attorney to review city records for a re-registration form for this tenancy or other evidence that this form was filed. And council provided a copy of the last re-registration form, which was in 2007. And so I'm wondering with that, it was after the hearing, and this is a question for you, Allison. I'm not sure how that works with our procedure. I know you have the hearing, and then there's something in the rent stabilization ordinance 60020.1 for reopening the hearing. So was this evidence, since it wasn't during the hearing, was it a reopening of the hearing to get that information from the staff attorney? And if so, was that all according to procedure that's acceptable?
I would point you to 60013. So the hearing examiner has the discretion to do any kind of investigation, to get any kind of information that the hearing examiner needs. There's not necessarily any reason to reopen the record. The hearing examiner has discretion to reopen the record to accept additional exhibits from the parties, for example. But in this case, there were no additional exhibits to find. So I think the hearing examiner in this case was just simply doing her due diligence. Typically, if a re-registration form has been filed, it's already in the decrease case file because the staff member who puts these files together in a case like this would automatically look for something like that. And so the hearing examiner was just being thorough in checking to make sure whether or not the re-registration form was there.
Thank you.
But just to clarify, that it is the landlord's burden of proof, right, to prove that they filed the re-registration form. So whether or not the hearing examiner did anything after the hearing is not necessarily dispositive. Is that
Right.
correct?
Yeah.
Commissioners, any further comment for staff? Very well. At this time, we'll be moving to oral argument for the parties. This appeal was filed by Lauren Kashefi. You'll be speaking first. You have 5 minutes total to offer an argument to the commission. The opposing party, Zeke Farrow, also has 5 minutes after you speak. As the appealing party, you have the opportunity to divide your time if you would like to rebut your opposing party's argument. So you have 5 minutes total, but you can partition that time into 2 segments if you'd like to speak first and last. Just let us know before you speak, and our secretary can keep a timer for you to save some time for you at the end. You'd be speaking from this microphone up here, so please make sure you speak directly and closely into the microphone. And also understand that we cannot consider any new evidence. We can only consider evidence that was present at the time of your hearing and weigh the hearing examiner's decision based on that evidence, just so you're clear. So if you'd like to approach the mic and state your name or your representative, you can be heard.
My name is Leah Clement, and I'm appearing for Lauren.
Okay, please speak directly into the mic, yes. And would you like to use your whole 5 minutes now, or would you like to save some for the end?
We'll save some for the end.
Okay, thank you.
Okay.
How much time would you like to, do you like to split it up, maybe 3 minutes and 2 minutes, or? Okay, let's do 3 minutes first. Thanks.
Well, basically, you know, we got this, we purchased this property, and, you know, we got it through escrow, and the former owner, this is already said at the other hearing. Oh, sorry. Oh, okay. The former owner of the property, you know, sent us over all of the documents, and one of them was, you know, the re-registration for Zeke, and this was brought up at the hearing, and at the hearing, you know, Zeke, he confirmed that signature was his on the registration form, and we had it, and it's just confusing to us that the old owner did not give this to the city. Now, I know that the burden of proof is on us. However, you know, we have the tenant acknowledging, yes, I signed it. He has paid all of his rent increases from 2010 forward with no objection. So, you know, possibly it was given to the city, it got lost. That's our standpoint. We just don't see how, if all parties are in agreement that the rental registration was indeed signed, the tenant agrees, yes, it was signed, you know, how we have to bear this responsibility. And I think that that's it for now. I don't know what else to say. Okay.
Thank you very much.
Okay, thank you.
Commissioners, do you have any questions? No? Mr. Farrow, now is your opportunity to speak. You have 5 total minutes if you choose to use it all.
And then just state your name and city of residence.
Sure, I'm Zeke Farrow, and I live at 7969 Norton Avenue in West Hollywood. Yeah, I acknowledge that I signed the form. The old landlord, I believe, did not file the form. The only reason we're here today is because there was a lot of work that needed to be done on my apartment, which was not done. And so when I went to the city of West Hollywood to address that issue, the city of West Hollywood is who informed me that the form had not been filed. I did not know that. So I was not paying my rent under the thought that there was a form that wasn't filed. And I've paid my rent on time every month for 8 years. And it took going to the city of West Hollywood to get my landlords to do the work on my apartment. That work was done, so that was withdrawn from my request for a rent reduction. The only issue left in the rent reduction was this issue of the MAR. I will say that the previous landlord of my building was over 75 years old. She wasn't necessarily the most organized person. The building wasn't always kept in the best of shape. And I believe that it's very possible that she did not file a simple form. That's it.
Thank you.
One question.
Question from the commission?
Yeah, I just have one question for you, sir. Setting aside this, if we were to assume that that this paperwork had not been filed on time, is the math correct? Do you agree with the math that's been done for the refund?
Yeah, the math is correct, for sure.
Thank you.
Commissioners, any further question or comment? No? Thank you. Lauren Kashefi, are your representative? Do you wish to rebut or speak more?
Yes, Mr. Farrow, does pay his rent on time. He's a good tenant. Mr. Farrow does pay his rent on time. He's a good tenant. But prior to the hearing, there was some issues that did come up about repairs to a door, and I forget a couple of other things, and those were just acknowledged that those were completed. They were done. And again, we don't know why, where the breakdown went, if it was with the former landlord, the city. We don't know which one. However, everybody acknowledges the signature on the pre-registration. And I just think that that should be enough to help us out here. And I think that's about all I can say.
Thank you.
Thank you.
Commissioner?
I actually have the same question for you. Is the math that was done by the hearing examiner, is that correct to your understanding? Let's say if it were true that the rent was collected and over, more rent was collected than necessary, have you done the calculation?
I don't, our accountant did the calculation. I'm not sure if she had an objection to it or not.
Okay, no one has expressed any, but I just wanted to double check
Right.
because I have some questions for staff about it. Thank you.
Thank you.
Commissioners, any further comment for any of the parties? Sure. So at this point, the parties are done with their oral argument. We'll move on to commission deliberations on this matter.
Question of staff first. So on page 6 of the pack, or the 6 of this specific item, page 20 of the packet, it has the breakdown of the rent overages, and I didn't quite understand why there were different numbers there and increases within 1 year period. It looks like between 2017, January, and December of 2017, including, it looks like there's a lot of increases in that 1 year period, and I don't understand why that wasn't in question or why that was legal. Page 20 of our packet, yeah.
So she's referencing a number of exhibits here, and I'm assuming that she's looking at the rent that the tenant actually paid. I don't know how those correspond to the rent increases. It looks like from December of 2015 to January of 2017, the rent essentially stayed the same. And then February to September, it went up and then it went down in October. So it doesn't necessarily look like it was increased inappropriately. It looks like there were different amounts that were paid in those months.
Actually, I think it does show somewhere in the documents, yeah, of one of the months. Maybe that explains one of the months that there was a $50 deduction for, I don't know, parking or something.
Right.
Okay. But both sides agreed. I just didn't quite understand that. Thanks.
In 2015, we had no general adjustment percentage. I think it's just stayed at 0. There was no increase.
I guess my only other question for staff is, can you remind us, and I know you've told us this before, and I understand that there's a significant role that this registration form plays since Costa-Hawkins. Can you remind us of the significance of that and why that registration is so important?
Sure. After Costa-Hawkins, because the city can no longer control the rent once a tenant leaves a unit, the only information that the city has as to the rent that a landlord is charging, and remember that landlord can charge an incoming tenant any rent that the market will bear. The only way the city knows what that rent is that is being charged, and the only way the city knows that the landlord is increasing the rent by only the amount allowed under the ordinance, is by the filing of a re-registration form. And that's why it may seem that the penalties are draconian for the failure to file it, but that's the only way post-Costa-Hawkins that the city has of enforcing its rent stabilization ordinance. And that's the reason why these procedures are codified in state law as well. It's not just our ordinance, but it's also dictated by state law.
Thank you.
I have a question on that. The state law doesn't require these specific penalties, right? It just provides for the registration, or?
No, it does. It specifically says that the amount charged in excess due to the failure to file a re-registration form can be restitution to the tenant, and it's not considered a penalty.
Okay, so it can be, it's not required to be. The city can, but is not required to have that be the remedy.
No, it only says that it's not a penalty. So what the state law says is you can't penalize a landlord, but restitution to the tenant for the overcharges is not a penalty. So in other words, this is not a punitive measure. So whether or not this was done purposefully, or this was an oversight, or this was just confusion, it's not punitive. It's simply a method of ensuring that the city has information about what the rent should be.
So the city has 3 years back is what it goes now. That was the city's own decision. If it wanted to go back less far or further, it would be able to do so.
That's
or even
correct.
if it were able to vary it based on the circumstances, could it choose to change the law and say that it could be between a couple months and several years, depending on the circumstances? And
Yeah.
Thank you.
Yes, absolutely.
On the issue of the burden of proof, this is kind of an unideal setting, in my opinion, for if there's a question of law, we review them de novo, which means for like it's new. And I took a quick look at the evidence code and at the case that was cited and a subsequent case, and I'm not persuaded that the burden should have shifted in this case. However, it seems a little strange for us to, since I don't know if this was on any of my fellow commissioners' radar, to really revisit that at this stage on this case. And I suspect even if it was that we would otherwise found that the burden of proof should not be on the landlord, in this particular case, there was evidence on both sides, and it was the standard is only the preponderance of the evidence, meaning that the hearing examiner found there's more evidence that it wasn't filed than that it was. So I'm wondering if it would be possible, I don't know, of course, how anyone else feels about this issue now, but is it possible for us to uphold the ruling, but without that piece of it of the conclusion of law, because with the preponderance of the evidence standard, whoever's burden it would be doesn't really matter because there's evidence on both sides. And it's more likely than not is the same standard, regardless of whose burden it is in this case. The reason I ask is because I would like us to revisit it, but at a time when people have time to read the relevant cases, and maybe if someone could provide a memo on it, because in other cases it could be a more important issue than here where there is evidence on both sides.
I really think that's a question for your fellow commissioners. I don't think it's appropriate for me to weigh in on that.
Okay. The legal question, I guess, was would it be possible legally for us to have a ruling that upholds the decision but does not have an opinion on that conclusion of law, saying regardless of who has the burden, it doesn't, the preponderance of the evidence the hearing examiner found was that there was no re-registration. Could we legally do that if we wanted to? Or if we were punting on that issue, would we have to remand it for reconsideration if we don't agree with the conclusion of law that the preponderance is on, that the burden is on the landlord?
So I would encourage you to look back at the hearing examiner's decision. I don't think that was a conclusion of law she made. I think that might have just been an analysis that I put into the staff report.
Okay. So anyway, I'm uncomfortable with I'm unsure of the conclusion of law. Evidence Code 500, which was cited, provides that except as otherwise provided by law, a party has the burden of proof as to each fact, the existence or non-existence of which is essential to the claim for relief or defense that he is asserting. So in this case, the default, were it not for other law, would be that the person raising the claim or defense has to prove it. So then there's a question of who's raising the claim or defense here. In my opinion, by filing a request for MAR and a request for relief, it is the tenant who is proposing a claim of relief. And then there's the question of this cited case, Wolf. From what I've seen, that's a very narrow case. It was an existence where there was a contract dispute that had some contingent monetary relief. The information only Disney had. The person who was suing did not have access to that evidence, and in that case where there was no way factually for the person to get access to the evidence, the court found that the burden shifted, but it was not for a final ruling, it was preliminary. Subsequently, 2 years or 3 years later, the same court, which is the court with jurisdiction here, the Second District, had a much more limited ruling. So anyway, I feel like it's worth examining those two cases and the evidence code and seeing going forward whether or not the evidence really, the burden should really be on the landlord, because I'm not convinced, but I don't feel like you guys have enough background now to really weigh that issue.
Just, can I ask a question? So if you could clarify a little bit for me. So you're questioning who the burden lies on, right? And then help me understand why that's relevant, because there's the document with both signatures that's produced, and it may or may not have been submitted to the city. Is that, but both parties had agreed on this? Or?
Yeah, well, it's a conclusion of law, and by adopting the decision, we're supposed to generally be adopting the conclusions of fact and law. So in this case, what I was hoping is we could just punt it and say, if we agree that it doesn't really matter to the core decision of who wins this case, then we could punt it and decide it later. But in a subsequent case, it would have been an issue had it not been for the hearing examiner talking on their own to the city staff, because there's another rule that says you can't make a decision solely based on hearsay evidence. So were it not for that, the only evidence of the fact that it wasn't filed would have been hearsay from the tenant saying that the city said it wasn't filed. And in any case, if there is only, it would matter in subsequent cases if there was not also evidence to support the tenant's position. In this case, I don't think it matters to the conclusion. It's just kind of academic, I think. But for the future, I think it's worth figuring out who has the burden of proof and maybe having people dig into those cases or get a memo.
I'm afraid that, from my perspective, I'm one of the non-attorneys up here, that you are truly muddying the water here. If an attorney prepares a motion or a response and then takes that to the court, that document is not complete until it's been conformed and stamped by the court. So while both parties may have signed off on this document, and I'm not saying they did or did not, but it was the landlord's responsibility to take this document to the city, have it conformed, have a stamp to show that it was received by the city. So this document was not deemed complete until there was proof it was received by the city. So I don't think we're punting on evidence. I don't think, again, as a non-attorney, this is just how I'm weighing in. I think you're truly muddying the waters of this particular case and perhaps anything coming down after this. I would be cautious. Perhaps that might be a discussion for our study session for a later date as to an amendment to our ordinance to reflect something along those lines. But I think particularly in their matter before us today, for me, the evidence is quite clear that while there's signatures on the document, there is zero proof anywhere that it was received by the city. And that is the defining moment for me on this. It is the landlord's responsibility to file that form with the city. We have no proof. So I would just be very cautious in the line that you're going with this. Because it might be a topic for a study session or to have city attorney, staff attorney do a presentation at a later date, but as far as the hearing before us today, I don't think this is relevant.
It's only relevant in that I don't feel like I can sign off on that conclusion of law having looked at those cases, and that was a conclusion of law in this, that the burden was on the landlord. That said, if we could legally do so, I am comfortable saying that we would uphold the decision because there was evidence on both sides, and the standard was the mere preponderance of evidence, so we wouldn't have to remand it because it's just which has the most evidence.
Does it weigh anything in that our precedent has always been to that the burden is always on, and in fact our ordinance says the burden, correct me if I'm wrong, but I believe the burden is on the landlord, and at least that's the precedent we've always followed. Does that weigh in your thinking at all, Commissioner O'Keefe?
What was cited in the decision was evidence code and a case. And looking at the evidence code and the case and a subsequent case by the same court that's controlling here, I wasn't persuaded by it. So if there was something else that would support that conclusion, it wasn't listed. I don't recall it. Like I said, I'm fine with upholding the decision given, other than that I'm not comfortable supporting that particular conclusion of law, and I think it would be worth something in the study session. I'd like us to see a robust discussion of what does the law say. If there is something in the Rent Stabilization Commission regulations or ordinance I'm missing, I'd like to see that for a future date. I'm just not necessarily comfortable with that conclusion of law based on what I read.
I just want to point out that what you're referencing is the staff report, not the decision.
Oh,
so
thank you.
what you would be upholding is the underlying decision. The staff report is a recommendation. That's where the burden of proof discussion comes. It's not in the hearing examiner's decision, and it's not in her conclusions of law.
So you're saying we can sign off on it since it's not in conclusions of law. I still would like some time us to explore that further when people have read the cases.
Commissioner Chopchian?
Thank you, Chair. I just wanted to comment on the fact that traditionally, historically, we always considered that the burden is on the landlord. That was set a precedent that that's the landlord's responsibility to file the re-registration form, and if a dispute arises, then the landlord would have to produce that evidence, the proof. Another thing is, I think in this case, the tenant is the only person who basically submitted that re-registration, which is not processed by the city. It's not stamped, as legal counsel explained. There's a certain procedure, so it's not stamped. So I would say the tenant met the burden of proof burden to prove that this application was not filed properly with the city. So, but I believe that, strongly believe, for all these years, being on the commission, we always considered that the burden to prove that the re-registration form is filed was always on the landlord, because the landlord benefits from the annual rent adjustments, rent increases. That was my understanding, and I believe that this matter was just in a discussion that the burden of proof was mentioned. But I'm fully agree with the I agree with the staff's recommendation, and fully support the recommendation, and I don't see any problem with upholding that. And one more thing is that, yeah, it was mentioned that after Costa-Hawkins, the re-registration form requirement was assessed and implemented, because the whole purpose of the rent stabilization ordinance to be able to control the rent, and the city was able to do that before Costa-Hawkins, and after Costa-Hawkins, law was passed in 1996. So this is the way the city can stabilize the rents in the city, and it's a very, I would say it's a fundamental piece of document that the owners have to file and follow the procedure. And again, I believe my understanding always been that this is the burden is on the landlord. Thank you.
Commissioner Gregoire.
I support staff's recommendation that we affirm the hearing examiner's decision, and I also support staff's draft resolution, which makes clear that the landlord bears the burden of proof. I appreciate Commissioner O'Keefe's concern. However, I think it is appropriate to include in the resolution a statement about the burden of proof, because the burden of proof was actually the basis upon which the landlord actually appealed the decision. So it seems totally appropriate to actually address it in the draft resolution. And I also support that statement that the landlord bears the burden of proof, because as Commissioner Topshian said, we've dealt with this issue many times over the years, and we've always reaffirmed many times, as far as I know, that the landlord does bear the burden of proof with respect to this issue. And I think it's really important to maintain the integrity of the rent stabilization ordinance. Therefore, I would support a motion to affirm the hearing examiner's decision on the grounds set forth in the staff report.
I would agree that I would be in support of the of staff's recommendation. I do just have a couple of points of clarification for the record that don't really, not totally germane to the matter, but they're in the record on page either 17 or 3, whichever way you're looking at our record, where the landlord said that the tenant is required to show proof of tenancy of re-registration before issuing a parking permit. Just because I volunteer for the sheriff's station and I issue parking permits every single shift that I work there, I will tell you that that document is not proof of residency for parking permits, City of West Hollywood. Lots of other documents are. That is not one of them. So that would not be germane to this matter. Also, the only proof that would have been required would have been the tenant to show their lease and who they were. So those are just points of clarification as far as parking permits, one of our little bugaboos. Other than that, I would agree with staff's recommendation.
I would like to point out the ordinance, which is 17.28.020, which is registration forms and procedure, specifically A and B here. A, initiating the registration form, and that initiation registration form must be a form provided by the city, which has been done here. B, which is very specific, when a rental unit is vacated and re-rented on or after January 1st of 96, the landlord must, within 30 days of the re-rental, re-register the unit by filing a complete re-registration on the form provided by the city. This ordinance is also supported by our own rent stabilization regulations of the city of West Hollywood, specifically 21,000, which is failure to register specifically, and 1, any landlord who fails initially register and pay registration fee shall not be entitled to increase rents above the base rent level set forth in Municipal Code Section 17.08.010 until the property has been properly re-registered, including a payment of fee. Not be entitled to pass through 1985 to 1986 registration fee to tenant, and be subject to late fees in the amount of 100% of the registration fee. That's all I have.
Thank you.
So I don't have any problems supporting the conclusions of law that are listed in the hearing examiner's decision, because they are all specific to our rent stabilization ordinance. I think that maybe a quick question for staff. This isn't considered a rent adjustment. Any reference to rent adjustment would be in reference to maybe some other issues that were earlier dropped in the case, right? A
Correct.
repayment of overpayment is not a rent adjustment.
Correct.
Okay. So yeah, I don't have any problems with any of the conclusions of law that the hearing examiner made. I do reluctantly also support the conclusion that the landlord should reimburse for the amount of $3,415.18. I think that this is a clear case that, while understanding the significance of the re-registration form, we clearly know what the MAR is without the registration form, because technically there isn't a re-registration form in this case, according to the city. And we've come up with a MAR, so this is proof that we don't need the registration form to figure out what the MAR is. I think this should be a case that we look at our study session to talk about whether we're meeting our goals of whether enforcement of something like this in a case like this really meets the goals that we're trying to set out and do. In this case, I believe that the tenant from day one knew what they were, what annual increases they could expect. I believe we have evidence in here that shows each year that the annual increases were correctly applied had the registration form been submitted. And I think there's enough evidence to also show that with both signatures on the form, we've seen many cases over the years of where the city doesn't have records. In fact, our next case coming up is a very apparent case where staff is recommending that we override hearing examiner's decision because even though the city had no record of it. So I hope that we can add a discussion to our study session discussions, and I know that there are potentially negative impacts to that, whatever may come out of that discussion. So I hope that staff can be there to really help us in understanding the significance of the re-registration form and why that is so necessary, and why we need to continue doing these procedures. But in this case, under our current law and based upon our precedent that we've followed for ever since I've been on the council, I am, again, reluctantly going to support the hearing examiner's decision.
I concur with a lot of what Commissioner Kirby said, and I would love to have a discussion of the justness of always having the same penalty, it's not a penalty, waiver, reimbursement of rents that were paid. In this case, there's some evidence on both sides. It does seem like from what I understand, a landlord could just mail in the copies, then their copy would never be stamped. The document that we have in our record shows that there's a yellow copy for the landlord. If they mailed it in, that might be all they kept. So it's entirely possible, you know, in some cases that it would be reasonable of them to just keep that, I would think. And in this case, the original landlord is no longer the landlord. That said, I'm pretty new to the commission, and seeing the difference between the staff report and the conclusions of law, I do think all the conclusions of law are accurate. However, the resolution itself says that the landlord has the burden of proving that was accomplished. And looking at the code and the case that are cited in the subsequent cases, I don't feel like I could sign on to that resolution. I could if that part of it were excised, but I'd have to vote no, even though I agree with the conclusion, because I do not think that I'm confident saying that's the case.
I can offer my opinion and just say that I do support the staff's recommendation on this appeal item. However, I am moved by Commissioner O'Keefe's comments. I do think that we are an appellate body charged with making decisions about the law, and any further discussion that we can add to a study session, I think, would make us better as a commission in understanding this burden of proof issue, and also the overriding policies that Commissioner Kirby's brought up in the sense of this particular case. I tend to be more of the mindset that when you do purchase a business, you purchase the assets and the liabilities. And this unfortunately was a liability in this case, and the RSO is clear that re-registration is required upon vacancy and re-rental, and that was not done, and that was not checked for when this new business was purchased or inherited. So for that reason, I am supporting the staff's recommendation this evening.
I'd like to make a motion to adopt resolution RSC 18-529, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision in application D-4318.
Second.
We have a motion and a second, so the motion is on the table. Secretary Trevor, may we have a roll call?
You may. I just wanted to double check. Who was the second on that? Thank you.
Was first.
Thank you. All right, Commissioner Kirpies?
I'm sorry, can I ask a question before we actually vote? Can I essentially concur and sign on to the conclusion of the resolution without that sentence, or if I disagree with the burden of proof, should I say no in my vote?
I think you have to say no. I don't think you can parse it out.
Okay, thanks.
Any further commission comments before a roll call?
Just had a question. I guess there's not, but there was a discussion about possibly amending the last line. I don't know if that resolves the issue you have, but
my motion was to affirm as is the staff's recommendation.
So Commissioner Topchian's not accepting any amendments to his motion.
Okay.
Commissioner Kirpies?
aye.
Commissioner Bergstein?
Aye.
Commissioner O'Keefe?
No.
Commissioner Maggio?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Gregoire?
Aye.
Chair Charity?
Aye. Thank you. The resolution passes. Parties, if you have any further questions about this issue, please direct them to staff. They'll be more than helpful for you. At this time, we'll be moving on from 9A to 9B. 9B is Appeal D-4325, address 1035 North Hayworth Avenue, apartment 208. This appeal was filed by James Lavoie. Is James present? Thank you very much. The tenant in this issue is Miss Barbara Linares. Is Barbara present? Thank you very much. At this point, can we have a report from our staff attorney? Thank you.
Thank you. Barbara Linares has been a tenant in Unit 206 since 2004 and pays $932 a month in rent. She filed an application for a determination of the MAR and whether the landlord had retained rent in excess of the MAR. The hearing examiner found that even though the tenant submitted evidence of a completed and filed re-registration form, because the city records did not have the form, she concluded that it was not filed. As a result of this finding, the hearing examiner found that the MAR was the initial rent of $850 and also found that the landlord had retained rent in excess of the MAR in the amount of $3,034. Staff recommends that the Commission reverse and remand the hearing examiner's decision. The completed re-registration form includes a stamp from the city indicating that the form was filed. That is all the rent stabilization ordinance requires. The landlord cannot control what the city does with the form once it's received. The hearing examiner erroneously found that the city's purported failure to process the form negated the proof of its filing. Further, staff recommends that the Commission remand the case for a determination of the MAR and excess rent in light of the proof that was submitted at the hearing to ensure that the rent increases that were imposed were actually lawful. Thank you.
Thank you, Attorney Regan. Commission, do you have questions or comments?
I have a question. Ms. Regan, do you have any recollection of any time that the hearing examiner has made this specific mistake where it's quite evident, it seems, that the form was processed by the city or received or acknowledged by the city? I don't recall any situation like this.
I don't either. I think it was just a mistake.
Okay.
As a human being.
Yeah. The other question I have is, the landlord is not in compliance and able to adjust the rent or increase the rent unless they have both registered the unit, re-registered the unit, and repaid any outstanding overpayment, correct?
Yes, I think I know where you're going with this.
I'm trying to understand how the hearing examiner could come to this conclusion. I'm wondering if that's how.
Oh, I'm sorry, then I don't understand.
So
well, I think the initial finding was that the unit had not been re-registered. So that was the basis on which the determination was made that the rent increases were unlawful. So everything else flowed from there.
Okay.
So I don't think she needed to reach the issue of whether or not there had been compliance because her determination was that the re-registration had not been filed.
Okay, so if I set aside my trying to make an excuse for her error in this case and just looking at the facts, the landlord would not be able to increase, take annual adjustment increases if they had not both re-registered and paid back any prior adjustment or increases that had been accepted without a re-registration form. The reason I ask is the tenancy started, I think, in 2004. Registration form pops up in 2015, and we're now in 2018 when the hearing is occurring.
So the issue with that is that because our ordinance does not allow us to go back more than 3 years, technically, while the AGAs were unlawfully imposed, there's nothing to repay. So if the tenancy, now that it's been re-registered, it was re-registered in 2015, essentially that's kind of a free pass because 3 years have since gone by, so none of those overcharges can be recouped by the tenant at this point. Does that make sense?
I thought our ordinance said 3 years based upon the re-registration or
whichever's later?
I'm sorry?
I thought it was based on the application because the application was not filed until...
It's based on two things. It's two dates, whichever one's earlier.
Oh.
I mean, that's how I'm reading
it. I'm reading
Maybe
that
I'm misreading.
incorrectly.
But
talk amongst yourselves. Let me look at that. I would suggest you hear from the parties, and I will go back and look at that to see if I've misread the ordinance, which is possible.
Commission, do you have any further comments for staff before we move to oral argument?
I have one question. Just looking at the record on page 103 is the January 25th letter from the tenant to Martin stating that the original rent of $750. Everything else in the record seems to indicate that the initial rent was $850. Is there any Question is to that dollar amount?
I don't believe so.
So it's the 850, not 750.
Right.
Okay, thank you.
Any further comment or question from the commission? Thanks very much. This appeal was filed by James Leroy. James, you or your representative will have the opportunity to speak first tonight. I believe you were in the room previously for my prior instruction, but I'll go over it for you again. You have 5 minutes total to speak. You'll be able to divide that time if you would like to save some time at the end to rebut your opposition's presentation. Just let our secretary know if you would like to be timed so you can save some time at the end. Please know that you can't present any new evidence to this commission. Only evidence that was on the record for your original hearing is all we can consider this evening.
I'll divide my time.
How much would you like to start out with?
Very short now.
Okay, I'll give you about 3 minutes.
It won't even need that.
Okay.
Yeah. Hi, I'm James Leovy. I'm for my mom, Norma Leovy, who was owner of the 1035 Hayworth apartment. The forms were submitted, and that's basically all I have to say.
Thank you very much. The tenant, Ms. Linares, you have 5 minutes to speak. If you would like to use your entire 5 minutes, please do so. Please remember to speak directly and clearly into the microphone.
I'll do 3 minutes. I'll do 3 and then 2 after if I need to.
So just to be clear, because you are not the party that filed the appeal, you have a 5-minute block in total, and that's it.
Okay, okay. My name is Barbara Linares. I live at 1035 North Hayworth, apartment 206. Moved in summer of 2004. I wasn't even aware of this registration thing. There were a couple of tenants that were having issues and had gone to court, and they informed me that that it wasn't registered. Our apartments weren't registered when we first moved in, and so I don't remember signing anything but the lease when I moved in. I did sign the form for 2015, and I was under the impression that it was illegal. Even though it was old, it was still illegal because they had also raised my rent a few times in 1 year. And I just, if I was I have no problem paying my rent, and if it gets raised, I understand. Even if I'm late, which I've been late a few times, but I'm not even sure what's happening now. So, I was very happy with the decision, but I guess that's possibly not going to happen. So I'm just going to leave it in your hands. I provided a lot of evidence and paperwork. I save everything. So, it is the landlord's responsibility to register. Plus, when I moved in, Mr. Lovy's mother was the landlord, and she passed away last year. And I didn't even know that for a good few months. So I'm still writing checks to her. So I'm just really confused about everything. So I just wanted to be resolved. And if, I get a reduction or whatever, I'd be happy with that. But I just do what I'm supposed to and pay my rent and try to hope that things are legal and up, straight up. So that's all I have to say.
Thank you. Commission, do you have any questions or comments?
Yes, I have one question. I'm just trying to find the form here. There's a form, the registration form that you did sign, the re-registration after vacancy, the one that you did sign later on. Do you recall that?
I'm sorry?
So in our packet, we have on page 95, we have a unit re-registration after vacancy form that does have your signature on it. It's well after the 2004. It's actually submitted in 2015, it looks like. I'm curious, do you recall signing it, and it's the dated 2013?
2013, I don't remember. The 15, I do. So.
Is it all right if I just show her the document so this is where we're on the same page, at least to understand what I'm referring to?
You can represent that the date says 2013. Is there a...
I'm concerned that she may not even know which paper I'm talking about.
And
It-
and that's,
It might be, if she can't explain it, I might have a question for you.
I mean, we can, it's page 95?
95 of our packet. It's the unit re-registration after vacancy form.
He's asking about this. Okay. So there was one for 13 and 15?
Just the one form from 2015. It just has the date next to your name there in the middle, signature of new tenant, 9/11/2013.
Okay, that must be, so there's just one, right? Okay, yes, I did sign that.
Do you recall, though, what year it was, if that's the correct, or?
I do not recall the year
Okay.
exactly.
All right, that's fair enough. That's 8 years ago, yeah. All right, thank you.
Thank you.
Thank you.
Mr. Lovey, do you wish to rebut or have anything further to say? No. Thank you very much. Thank you. That concludes oral argument for this appeal item. We now move on to deliberation for the commission. Would anybody like to start? Oh, yes, there was a question, yes, pending. Mm-hmm.
Yeah, I may have been a little bit off now that I'm reading both sections, or?
No, I think you're right on. I mean, you, Commission may disagree, but so I'm at 17.44.040, number 1D, little 1, and it says a tenant may apply to recover illegal rent overcharges resulting from a landlord's failure to file a re-registration form, except that no tenant may recover overcharges collected more than 3 years before the filing date of a re-registration form or a rent adjustment application by the tenant to recover the overcharges, whichever is earlier. So that seems to indicate to me that because the re-registration form was filed in 2015, that the tenant is entitled to recover the 3 years prior to the filing of the re-registration form.
So it's from the date of filing the re-registration form, not the filing the application with the department.
Do you want to I don't think the commission has that language in front of it. I can give you
Yes, so in our RSO packet, this is on page 17-29 for the commission's review.
Is the limitations period an issue for us on appeal tonight, or it's being remanded?
Well,
the recommendation is to remand it, correct?
So that's very true. You could remand it to the hearing examiner and have the hearing examiner look at that issue as well.
Okay.
Yeah, and
That
if we do go that route, I do want to clearly point her in that direction, at least so that she knows that we're focused on that area of question.
And the ordinance that you pointed out was
17.44.040. Number 1, letter D as in dog, and then little 1.
All right, thank you.
And can I continue? And the reason I don't know if this is really a question or a comment, just so you know what my thinking is in terms of why I asked the question about the 2013 is, it's being proposed to us as a question of law, right? This appeal, your recommendation is look at it as a question of law and whether the law was followed in terms of the registration was submitted or it wasn't submitted, because there's evidence that says
issue. Right. I think they're both. I think in this one, if I'm remembering correctly, they're both factual and legal issues. But in any event, go ahead. Continue.
That was the reason I was questioning, because I see this as a factual thing that there's so many questions about this form that it was. I'm only thinking of 2 right now, but the tenancy started in 2004. This form was signed in 2013 by the tenant. Don't know when it was signed by the owner, but it was submitted to the city council or city in 2015. That to me is odd, but then what makes it more odd is the city has no record of it. So no one's, I mean, I have a black and white copy of this. No one is making an allegation that, you know, it was falsified anyway, but had that allegation been made, I don't know, this just seems an odd situation where someone would hold on to the document, or 2013 could be an error.
Well, the issue before you is whether or not the re-registration form was filed. And so you have to look at the evidence before you and decide whether or not the hearing examiner was correct in concluding that it was not filed. Mm-hmm. And if you conclude that that her finding was not supported by substantial evidence, then you'll reverse and you'll remand to then answer the questions that we've raised today.
Question. So on the form, there's a stamp on the page 95, and it says received by the City of West Hollywood, 15 March 11. Normally I would read that as the 15th date of March in 2011, but that would be 2 years prior to the date she signed it. What does that mean exactly?
So the first number is the year.
Okay,
so it's
the 11th of March 2015. That's what you're saying. Thank you.
I guess I'd just say I support staff's recommendation that we should reverse and remand the hearing examiner's decision. And based on Commissioner Kirby's comments, I would support, amending the resolution to specifically ask the hearing examiner to consider the appropriate application of the statute of limitations.
Just want to make a quick comment. It was really interesting when I also reviewed the packet, the dates, and I'm glad the fellow commissioners, Commissioner Corpus, who brought up I had the same confusion with the dates. It seemed like the form was signed in 2013 but filed in 2015. The interesting thing another is that in this case, we have, again, just like in the prior case, a tenant submitted the form, but here we have the stamp, and that's the reason why in the prior case I wanted staff to explain the process of filing the application, the form with the department, and that's what it is. The stamp is important, and before us tonight, in this case, is the question is whether the application was filed or not, the form was filed or not, and clearly the form was filed with the department, based on the also the records, and I'm glad that Commissioner Kirpus, you pointed out on that issue that will be in any ways remanded to the examiner, and with the maybe caveat to look specifically into that matter that we discussed, and I'm fully prepared to support the staff's recommendation in this matter.
I also appreciate Commissioner Kirby's raising that issue that was not on the radar. I think this would require a revision to the resolution by striking the last line of the second to last paragraph that says, therefore, Ms. Linares, sorry if I'm mispronouncing your name, is not entitled to a refund of any overcharges collected between 2004 and March 2015. I think we need to strike that then, in addition to probably adding some language with further direction.
So just to confirm, Commissioner O'Keefe, you're proposing striking just the sentence that begins therefore.
Correct.
Got it. Thank you.
Wait, let me double check.
Sure.
Because I didn't have time to read this except during the deliberations.
I would also recommend accepting what Commissioner Gregoire said. In addition to striking that, also say just what you said, to consider the appropriate application of the limitations period under 17-44040.
Yeah.
I can add that.
One thing we should probably do is simply make a motion, but not attempt to adopt a red line resolution, and staff can bring a revised resolution to us.
Absolutely, I'll bring
at the
it
next
back
meeting.
Next time. Yes, but
Okay.
yes, do adopt what you've just discussed.
I'll make that motion unless somebody else wants to comment. So I'll move that we adopt the staff recommendation to find the hearing examiner made an error in the determination that no re-registration form had been filed, and remand this back to the hearing examiner for further review, and specifically to those ordinances, and staff will bring back the ordinance, or bring back the resolution to us. Does that work?
Yes.
Is that sufficient? Okay. That'd be my motion.
Thank you. So we have a motion by Commissioner Kerpes, seconded by Commissioner Topchian. Motion is on the table. Are there any further commission comments or questions before we have a roll call? Thank you, Commission. Secretary Trevor, may we have a roll call?
You may. Commissioner Kerpes?
Aye.
Commissioner Bergstein?
Aye.
Commissioner O'Keefe?
Aye.
Commissioner Maggio?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Gregoire?
Aye.
Chair Charity?
Aye. Thank you very much. Your motion passes, Commissioner Kerpes. Parties, as I stated earlier, if you have any questions or comments about the proceedings tonight, please direct them to staff and they'll be able to help you out. At this time, we'll be moving on from item 9, appeals, to item 10, public comments. Staff, do we have any public comments tonight?
Not at this time.
Thank you very much. We're moving on from item 10 to item 11, commissioner comments. Commission, do we have any comments?
Just a couple of things. Wanted to point out that the Apartment Owners Association of Greater Los Angeles is reforming the West Hollywood chapter. The first meeting will be on September 27th at 6:30 upstairs, so I may pop in for a brief moment before our meeting starts that night, but want to encourage any and all West Hollywood landlords to get involved in that initial meeting on September 27th, 6:30 p.m. in the room upstairs. Second, Anwar, I've been discussing this the last couple of meetings, my comfort level with our department moving towards all online forms. And I consider myself to be a relatively computer literate person. I didn't come out of the womb with a computer, but relatively good. And I went online to get the 30-day notice to change in tenancy, as well as the annual adjustment worksheet. And I had difficulty finding the forms. So if we can just continue to make staff aware that if we can find a way to make locating those forms much more prominent on the city's new website and on the rent stabilization area, so it should be just a really quick click, here's all of our forms available online, because I really had to kind of dig through a couple of layers before I found those forms. And lastly, while this is not specifically a West Hollywood landlord-tenant issue, my partner Raul Cobian owns a number of rental homes in Lake Elsinore, one of which is directly below the fire line. It's creeping up right on the property line. So he has made arrangements for his tenant to move their belongings out, just as an abundance of caution, but I would just ask that we remember all those affected by the many fires across the state. Keep the safety of the residents and the firefighters in our minds. Thank you.
Just probably a question. I know we spoke before about the buyout agreements. The discussion is coming up sometime soon. Just I don't know why it struck me. I remember.
Yes,
maybe I saw you, Allison, because I remember you reported on that issue.
Yes, we were going to bring that along with the tenant habitability plan issue to the City Council. We were going to bring those together. And frankly, I would urge the commissioners to maybe prod their city council member to ask staff to bring the tenant habitability plan forward, because that has stalled. And what I can do is, if it continues to be stalled, I can just bring the buyout agreement separate from it. Ideally, we'd like to bring them together, but I'm not sure what the holdup is with the other one.
So you would prefer to have them together, kind of reviewed at the same around the same time?
It's nice to have, you know, revisions to the ordinance all done at the same time, but it's certainly not necessary.
All right. Thank you.
Thank you.
Any further commission comments? Thank
you. Just a question on that. So as the tenant habitability, when you say bring all the changes to the ordinance at one time, are these does those all fall into the rent stabilization ordinance, or are they also spread out throughout the various other ordinances as well?
I think the tenant habitability plan touches a few other ordinances as well, yeah.
And then I would just like to, in my comments, I'd like to formally request a discussion be added to the agenda for our for our study session on the re-registration form, background and education, and an ability to not take any action, but an ability to discuss some various scenarios and impacts, and that would involve staff as well, obviously, because you'd be the one telling us the information. So I'm hoping that we would be able to have that in time for our study session. And so I move that we add that to that agenda.
Do you want that added to the agenda? Typically, the tradition has been at the annual study session, we actually just brainstorm topics to agendize. And do you want it actually agendized for that particular meeting, or do you want to wait for it to be agendized at a future televised meeting?
I do, because I do want it agendized for that sort of meeting, because I know that this is an important piece of how our ordinance works and operates, and I want to make sure that we are fully educated and maybe have more questions, and we have a free discussion, basically, kind of what our thoughts are and what our questions are. So then if we do decide to potentially take action at a future date, staff will know what our questions are, know what we were throwing around, all that, so that they're even more prepared to assist us later on. That's my reasoning and thinking for that.
I don't have any objection to agendizing it. Is that something that has to be separately agendized for that night?
We wouldn't be taking any action. I'm not asking for action. It's like an educational thing for that night.
But as Commissioner Gregoire said, it's usually the study session, it's just everything is brought up and is discussed at that time. And then whatever you want, as you prioritize it, then it's discussed later. So I don't know if you can agendize it or not.
I mean, I don't think that you need to separately agendize it. I think that you can bring it up as a topic that you would like to speak to at a future date. And then if you want some information about it, consistent with the other topics that you raise at the study session, I think we can do the same kind of thing with respect to that issue as well, if that's similar to what you...
I guess they just view this differently than a, tell us how it works with how rent increases work, or tell us how, ADA compliance issues work into the housing policy. I'm not asked what... My intention is to change the ordinance at some point, and I want to be fully educated on that before I agendize that for a future meeting. I think tonight's this really it's always been something in the back of my mind, and I know that I've always understood this is a significant role.
Yeah, I think announcing that your intent is to change the ordinance, I think considerably changes the calculus. Then I think you're gonna. I would recommend then that this be agendized for a future meeting as a topic for a televised meeting rather than a study session, because it doesn't sound like, if your intent is to change,
Well, no, so based on the knowledge I have right now, my intent is to someday change the ordinance to make it more fair for people in the situation that we just saw tonight.
So because
but I know there's
already
more
reached,
to it than that.
Because you've already reached the conclusion that it's not fair, then that's not something that you can address in a study session. You see what I mean? So that type of debate is not a study session topic so much as a debate about what is or is not fair, what is or is not consistent with the goals of the rent stabilization ordinance. So for something like that, it's both informational and a debate topic. So I would recommend that come before the commission as a standalone item at a future meeting.
Could we both, because with the seismic retrofit, there was items that were before the commission as agenda items, and then there were separate sessions with the community that were separate. I'm wondering if we could both vote tonight on whether or not to agendize this item later, and then with it on the agenda for the future, get background information that's not us debating the merits of it, but just understanding the factual background? Or are you saying we cannot do that then? It has to be in the future meeting because there's a desire to debate it?
Well, I think that's what I would recommend is something more consistent with the Sizerk retrofit, which is, have community meetings devoted to this issue. Right now this is a general study session on August 23rd. So if you're going to debate this particular issue, that should be something that, is its own kind of process, if you will, where there are separate public meetings to just what Commissioner O'Keefe described, get the community's input, and then you can have, so that it's something that the community understands what is actually happening and can offer its input. That's kind of in the name of transparency.
Yeah, no, I'm
not implying that you weren't trying to do that, but I'm just.
I guess, sure. If I guess I can change my motion to the September 27th meeting. I want it as soon as possible so we can. But this is not an action item. At least for the first time it appears on our agenda, it's not an action item. It's just an education item from staff that will allow us to also discuss various scenarios and what the impacts of those scenarios could be, should the commission want to recommend a change in the future.
Second.
I got a little lost in the conversation, so I think what you're proposing is that we agendize it perhaps for September 27th for staff to make a presentation. At that point, this commission will discuss it, and we may choose to bring it back as a public process for further review within the community after that initial meeting. Am I correct?
Correct.
Thank you.
And I'm sorry, one clarifying question. Is the scope of this the actual process of registering and what that happens, looking at that? Or is it looking at the, not penalties, but the relief that's granted if there is a failure to re-register, or is it both?
I would say using something similar as a case scenario that we just saw, what the benefits and consequences are of altering the process in any way. So I would say from start to finish.
Got it.
Without going too far out on, necessarily the 3 years or the, not the other issue that came up this evening. I'm not necessarily interested in the 3 years to what date. I'm interested in just the process alone of re-registering that document and the impacts it has on rent increases. So start to finish without getting off topic, which I just did.
Logistically, for September 27th date, if we were going to look at past cases before this commission that involved that issue and public policy of the laws as they are, is that logistically time enough to prepare that kind of presentation for staff?
I don't think we can give you like an overview. I could give you sort of random samplings, but I would also caution the commission that what comes before you is not representative of what's happening. I think we've given the talk before. We've sort of narrowed down. We've given you the universe of rent stabilized units in West Hollywood, and then the portion of that in which there's conflict, and then the portion of that in which a tenant or, in which a rent adjustment application is filed, and then the portion of that that comes before you. So just remember that what you're seeing is the most, the situations that are the most in conflict or the most, and so I don't know that that would be representative of anything of the process. I think you might need to take a more global look at it and the goals behind it. But I can certainly, give you some scenarios that have come before you. But again, I would just caution that that's not necessarily representative of what's happening in the larger community.
And I think what you're saying is exactly what I'm looking for. Is I just happen to have a case in mind right now that is, to me, I'm questioning whether it meets our what we're trying to intending to do. But I have also seen many other cases where it's not as one-sided that I'm feeling this case was, that are all over the place. And I don't want to, someday if we ever decide to change the ordinance, I want to understand what implications that will have, because
Right.
it may
Well, I
have.
guess my larger point is that most landlords in the city adhere to the law, and they have an awareness of what the penalties are for not doing so, and that provides a great incentive to adhere to the law, and that's one reason why we have such high compliance, and one reason why we're able to stay on top of the rents in the city.
But not penalties. I said, but not penalties.
Yeah. Right.
I would point out, I think we kind of went through this exercise when the commission made a recommendation to the city council on amending the statute of limitations. So we did study it at that time. I always want to support a fellow commissioner's desire to agendize something, but I really don't support the concept of opening up this can of worms again, because we already went through this exercise. I don't know how many years ago that was when we did amend the statute of limitations, and we did it to we felt that would make it fairer to landlords.
And if you'd like, Commissioner Kirpies, I can try to go back and find the the reports on those discussions, if you think that would be helpful. And then if after reading that you still feel the same way, we can. But maybe I can provide that. I can provide it to everybody assuming I can find it.
That'd be great to include in our staff report for that night, that we could read before. I mean, I'm sorry. But no, I definitely do want that. Please.
It's just if it's enough, again, I don't know if staff will have enough time to do that, to prepare and to provide all that information before that meeting.
My motion is September 27th.
And it's got a second, so
Exactly is the motion.
Right, we need to clean that up a little bit, because when you proposed it was kind of drafting it, so we'll clean it up a bit.
So correct me if I'm wrong,
okay.
but my motion is that we have a discussion on the formally requested discussion on the re-registration form, background and education, discussion of scenarios, so that we can fully understand what the importance of the re-registration form, the significance, and implications of potential changes.
Well, I support your motion in general. I'm a little concerned about the date, that if this is going to be a particularly, it could be a really significant discussion. I don't want to rush staff into just giving us, what they can kind of pull together by September 27th. So I know that you want this done as quickly as possible, but I'm not sure in the grand scheme of things what the difference would be if we were to give staff perhaps another month, or they were to tell us we need this much time to really properly prepare to bring this presentation. So I don't know if I can offer a friendly amendment, or if I just vote no. I'm not sure what the procedure is, but yes to your proposal, but not to the time to bring it that quickly.
Mr. Chair, I would also, I'd like it to be given to staff and for them to come back and tell us when they could do this, because it could be a tremendous amount of work, and it's going to take more time, and I know they're short of help, and but I think it's a good idea. But I think we should just present it to staff, come back, and tell us when they think they could have this information, so that we could have a full discussion.
Yeah. I guess for the reasons I already stated, I oppose agendizing this item.
I would like at some point to discuss the issue of whether or not we should consider amending the amount of relief that tenants get, so it's not necessarily always a flat 3 years if there wasn't a re-registration, potentially having it be less in some cases. So I don't know. It sounds like that's outside the scope of what Commissioner Kirpies is talking about, but I guess maybe, am I correct? You wouldn't want that as an amendment to your proposal. That would be separate?
It wouldn't at this point, because I think now we're discussing kind of the merits of the...
Okay.
I mean, that's kind of my feeling, and I want to kind of keep it as broad as possible, because I don't think this is going to take, I mean, I was offering to do it in an informal discussion. That was recommended it to be not done by staff. I have not heard staff say that they cannot prepare a, this is an item that they have to defend all the time. So there should be an answer why this shouldn't ever be changed. I mean, that should be they should know that answer already. Now, to put it in a more broad, just rather than one sentence, yeah, that's going to take them a little longer. But September 27th, I want this done sooner rather than later because I worry that a case like this might come in front of us again, and I can't continue to support what happened tonight.
And this is in flux, of course, because they're shifting to electronic registration, so some of the things will be changing, which I guess we would learn about if we were to adopt this.
Honestly, I don't really see an urgency to really to agendize this like urgently. We have to discuss, we have to recommend, we have to change things. Again, for years we've been dealing with this issue, and obviously traditionally we had that process set, precedent set, and we never really had any issues, any problems. So that's why I don't really, my personal opinion, again, obviously we have the motion and the second, we're gonna vote on it, but I don't really see like an urgent situation that we really have to discuss this because something is really going wrong. So that's my opinion.
I was very alarmed that there was a case where it looks like something was filed and it wasn't in the records. So to me, that creates kind of an urgency. We've got a situation where if somebody didn't happen to have that stamped copy, there would have been a requirement that the landlord pay back rent when they had in fact filed, according to our ruling. So that to me is kind of a pressing need. Something went wrong.
Yeah, because clearly the owner didn't file the form. That's why there is no stamped copy, period. So the tenant had the form. If there was a stamped form, the tenant would have.
No, she's referring to the stamped form, the second case.
Well, the second case is clearly there's a stamped form. If there could be a human error. If somebody misplaced the form application back in several years ago, that's acceptable. So there is, even if you adopt the best ordinance or change to the ordinance.
Sure, I still think we're getting off subject. We're now debating the item that's not on the agenda tonight.
Yeah.
All I'm asking again is to put this on a future agenda, September 27th.
Could I call for a vote on what has been proposed with the date that's been proposed, and if that does not pass on that vote, then perhaps we would bring a second motion with a different date. But I think time to call a vote.
Yes, if there's no more commission comments, may we have a secretary? Mr. Secretary, may I have a vote?
Yes. Commissioner Krippies?
Aye.
Commissioner Bergstein?
Opposed?
Commissioner O'Keefe?
Aye.
Commissioner Maggio?
No.
Commissioner Topchian?
No.
Vice Chair Gouguar?
No.
Chair Charity?
No. Now, just to continue commission comments, I am very open to this being agendized, but with a more open, flexible date for the staff, only because I am sensitive to the logistics of the staff putting this together. And I would like, I agree with what you're saying, because I think any time that we think we have a knowledge deficiency on an issue, that it could only make us better to have a presentation on it and learn more about this particular issue and grapple with things in the law that we have to confront. So just to let you know, I am open to voting for a motion with a more open time schedule.
So I don't think I can make a new motion on the same item, so I'll leave that to somebody else. But to just counter the comments, again, I did not hear staff oppose what I was proposing. Moving on to my other comments, I would like, I've asked in the past, and I believe it is being worked on, it's just that we haven't gotten a report, is I think it was as a result of the hurricane in Puerto Rico, but I would like to hear a staff report or a report from staff on kind of the thinking of what we are doing in preparation for a situation like an earthquake or something here that where we find ourselves the following day with numerous apartment buildings that may not be red tagged yet, but are broken up, and still landlords are still requiring rent, and tenants are still required to pay their rents. What the city has planned for that, I think Peter will have more information on that, because it's something Peter and I have discussed in the past. And the other thing was, Costa Hawkins is coming up, or the vote on Costa Hawkins is coming up. The city of Santa Monica, I think, has potentially made some grave errors in some of the things that their rent control board was going to review. They had intended to look at changing their, I don't know if it's their charter amendment, whatever their regulations are bound by, about making it so that their citizenry could vote on the same day. Prop 10, vote for Prop 10 to get rid of Costa Hawkins, and vote at the same time on the same ballot to reinstate some of the probably the things that are probably most offensive to landlords, which are the vacancy control. They luckily decided not to put that on their ballot. I think that was a good choice not to do that the same day, because I think it gives opponents of Prop 10 a place to look and say, see, look, they're already doing it. They're going to go back to this if we pass Prop 10. I think that we need to be thinking about that in how we might need to change our ordinance in the future, or if there's a plan for how we want to do that. And then also be thinking about that as we see cases like tonight, that I think is not going to add or build the case for rent control. Cases like that the average person is going to see and say, this doesn't seem fair. So just if we keep that in mind as we move forward, and that's, I think, all my comments tonight. Thank you.
Can I would like to offer to go back to your original motion, with the only change being that to ask staff to come back at our next meeting, tell us when they could agendize it and fully prepare. So your exact same language, because I don't know how I'm going to vote either way, and I'm interested to hear the process. I also want to allow other commissioners to bring up topics for discussion, whether I agree or disagree. So I would go back to your original motion, asking staff to come back at our September 13th meeting with a date at their earliest convenience when they could properly present this to us for consideration. So that would be my motion.
And I second that motion.
Commissioner Kerpes?
Aye.
Commissioner Bergstein?
Aye.
Commissioner O'Keefe?
Aye.
Commissioner Maggio?
Aye.
Commissioner Topshian?
Aye.
Vice Chair Gregoire?
No.
Chair Charity?
Aye. The motion passes. Thank you. Do we have any further commission comments?
So I would like to talk at some point about the question of the burden of proof, and to have those cases available to my fellow commissioners upon which that depends on. And I don't know if this is maybe something we could just, I don't know if we need to formally say we'll add it to the study session, but I'd like at some point those actual cases to be provided and us to look at them and talk them over and make sure that we think that what we've been doing is legally sound.
You could bring that up at the study session on the 23rd, right on the floor where we'll be meeting.
Is that sufficient, Commissioner O'Keefe?
I didn't hear you very
Oh,
well.
you
I'm
could bring
sorry.
it, he said you could bring it up at the study session on August 23rd for discussion.
Okay. Would it be possible for us to just have those cases sent around in advance of that, just so people have it in front of them as well?
Sure.
It would have to be after.
Sure.
And any other ones you think are relevant too. Just anything so we can have what we need to evaluate
I think
it.
generally just the way the study sessions have worked in years past is we throw a lot of darts at the board, different topics. We don't go into any depth discussion or preparation. We kind of just we all bring up whatever topics we would like to see discussed further throughout the year. Then we kind of rank those, bring them back. So I think it would be, at least from my understanding, premature to ask staff to bring any cases for us to consider at the study session. I think we'd have to wait until after we've ranked it and bring it back for the full commission to consider that time. So I think not a bad idea, just premature. Not a study session kind of a topic.
Staff said it's okay, so I don't know what the feeling of the other commissioners are. I don't think we have to do things how we always did them before. It doesn't necessarily have to be a huge discussion, but I personally think it's worthwhile to have been able to read the cases first.
I think the topic has merit, and it's something we should discuss. And usually something like that, it's much easier to launch it from a study session. And like Rob said, we dart it, and I think that's the way to do it, and get the interest not only from your fellow commissioners, but from the staff as well.
You know, I guess my only comment is, I think the burden of proof is settled law in the city of West Hollywood with respect to the rent stabilization ordinance. Obviously, as a lawyer, I don't mind reading additional state court cases that talk about burden of proof, but I believe it's long settled law at this point, and I don't necessarily think we should revisit it at this point. But you know, as I said, I'm not generally opposed to not discussing things. I just don't think we should be agendizing a discussion of whether the burden of proof is something that should be changed in the city of West Hollywood.
I agree with you, Commissioner.
So, I agree that this is something that, and the reason I say this is because I've experienced, I know some people, or maybe we all have been through a staff study session. I'm not sure if we all have, but so the ones that I've been through, I do see this as something that we could bring up, like what you're bringing up. Just staff would send us the case that you're asking for. I wouldn't know what to do with the case necessarily until we had the discussion on it, but I think it's something that you could bring up as a future discussion item because this one is something that we are so unfamiliar with that it would be a new topic for us to even bring up at the... And
let me make a suggestion along these lines. This doesn't come up very often in the cases that we analyze, but it's, I would say that it's hard to discuss this topic just in the abstract. And so I think you need a set of facts. And so I would encourage the commission to wait until there's another case in front of you where this topic is raised. And I will do, I've kind of glossed over it because, like the other commissioners, this wasn't really an issue for me. I just was assuming this was settled, and the law seems very clear to me. But if you would like me to do a more thorough analysis of this issue in a future staff report so that we can have a more robust discussion in the context of a case, I'm more than happy to do that. I guess I haven't researched this issue enough, and I'm reluctant to just sort of throw case law at the commissioners and say, here, have fun. So I would prefer to do my job and analyze this issue in the context of an actual dispute so that it has some context to it, and then we can look at it in that.
I like that idea a lot. Okay. So the next time we have a case that involves the burden of proof, you're saying maybe you could look at all the cases, do a legal memo, then we can look at your memo and know the citations and maybe have them if we want to look at them, but read your whole, here's the reasoning. I think that's a great idea. Okay. So we won't talk about the study session.
Thank you very much. Are there any further commission comments? I would just like to commend Commissioner Kerpes and Commissioner O'Keefe for delving into these legal issues before us tonight. It really provided some very fruitful conversation for us, so thank you for making us better. Thank you, Anwar, for visiting us tonight and filling in. We appreciate your contribution to the meeting. Before I move on, are there any other commission comments?
No, thank you.
Very well. We're moving on from item 11 to item 12, staff comments. No comments from the staff?
I'm good.
Well, then the next regular meeting of the Rent Stabilization Commission will be held August 23rd, 2018 in West Hollywood Park, Public Meeting Room, Council Chamber. This meeting is adjourned. Thank you very much.
I don't need it, do you? Leave it for him.